Namaste, one and all. I'm Sridevi Jampani, founder of Igna Legal. As part of social responsibility, we have been conducting online classes to the upcoming advocates on the daily basis, and at the weekends we have been conducting webinars for all the advocates community. In this process, when I requested Sri PSP Suresh Garu, Advocate High Court of Andhra Pradesh and Telangana, he accepted to give his lecture on Andhra Pradesh rights in land and Pattadar Passbook Act. Before starting the topic, let me introduce today's speaker, Sri PSP Suresh Garu. Namaste, sir. We welcome to you to the today's webinar. He is a practicing advocate in the High Court of Andhra Pradesh and Telangana. Initially, he practiced in the High Chambers of Sri Justice A. Rajshekar Reddy, former Judge, High Court of Telangana, before his Lordship elevation. Worked as Standing Counsel of Customs, Central Excise, and Service Tax Departments in the Composite High Court of Andhra Pradesh for 8 years. Also worked as Standing Counsel and Special Public Prosecutor for Enforcement Department and dealt various cases on behalf of ED Department. Appointed as on-record advocate for Andhra Pradesh High Court and Subordinate Judiciary in the year 2019 to defend before the High Court of Andhra Pradesh. Also worked as standing counsel for AICTE and UGC to defend before the High Court of Andhra Pradesh. Serving as chief editor for the Andhra Law Times Journal and author of a book, Law Relating to CBI and ED. Recently elected as Vice President of Andhra Pradesh High Court Advocates Association. We welcome you, sir. Please kindly start the lecture.
Good morning to one and all. I am thankful to the Egna law firm for asking me to give a lecture on this. In fact, I was benefited of reading all these provisions once again for the purpose of saying to what I could understand from the acts. I will just explain to you people. I am not sure that I am absolutely correct or I am 100% acquainted with all the things. Whatever the little things I got, I just share with you. So good morning to one and all. See, the today's topic which was given to me is uh, AP RO Act 1971 and also the new enactment, that is Andhra Pradesh Land Titling Act 2022. So before going to these two enactments, I will start from the Transfer of Property Act. Transfer of Property Act is the enactment which came into force in the year 1882. In India, there are two properties we know generally: movable property and immovable property. We are now concerned with only immovable property. In India, the mode of acquiring of title to an immovable property is under the major enactment. This is the 99% of the acquisition of titles will be under the Transfer Property Act only, 1882, by way of sale, by way of gift, by way of exchange. Like this, there are various modes of acquiring of title under the Transfer of Property Act. Apart from Transfer of Property Act, we are having special laws, that is succession laws, Hindu Succession Act or Indian Succession Act. These two succession acts also confers title on a particular person depending upon his right to claim property under the succession act, succession laws. Apart from these two enactments, we are having some special enactments like in the state of Telangana and Andhra Pradesh, we are having tenancy acts, Hyderabad Tenancy Act, Andhra Pradesh Tenancy Act, abolition of Inams Act, abolition of Jagirs Act. So under these enactments also, the riots or the persons who are in possession of a particular piece of land and enjoying as on the cut-off date given under these enactments, the revenue officials are given the power to issue occupancy right certificates. That occupancy right certificate is a title document for those people. So these are the various enactments in the country which deals with the conferment of title to a particular piece of land in respect of a particular person. These laws are on one side. Apart from these laws, the state laws like AP RO Act, we can also take Panchayat Raj Act, now the latest Land Titling Act, or Municipality Acts, municipal laws. These are the local enactments brought into existence for the purpose of maintaining of records. Second thing, collection of revenues or cess, we can call them as cess or tax or something, duties or something. And also for the purpose of maintaining and updating of the records of the revenue, records of the panchayat raj or municipality, and also records of the land revenue officials. For the purpose of maintaining of these records, the first enactment that was brought after the independence, that too after mixture of the Andhra Pradesh state and the Telangana Nizam state, is AP RO Act 1971. This 1971 Act underwent various amendments. The purport and object of this particular act is meant for the purpose of updation of the revenue records. Whoever acquired title over any particular property by way of any of the modes which we just told, either under the Transfer of Property Act or under the Hindu Succession Act, the title will be recorded in the records maintained by the revenue people. We need to have a clarity on this. The revenue authorities has no power to decide the title. What they will do, they will record the names of the persons who already acquired title by way of the existing laws of title laws. So the applicability of this AP RO Act 1971 is initially was only for the agriculture lands. We can see section 2 subsection 4 of the AP RO Act 1971. It was amended with effect from 29/7/2021. The definition of land was amended by way of Amendment Act 2021, that is Act number 33 of 2021, with effect from 29/7/2021. Let us see what is the law prior to this amendment. The old is land means, I am reading section 2 subsection 4 of the unamended for first section. Land means land which is used or is capable of being used for the purposes of agriculture, including horticulture, but does not include land used exclusively for non-agricultural purposes. So the 1971 Act, prior to this latest amendment, is intended for agriculture lands. Now what happened is, by virtue of amendment to section 2 subsection 4 with effect from 29/7/2021, land means all lands irrespective of its usage falling within a village, including agriculture land, non-agriculture land, and gramakantam, etc. So the difference in between the amended act and unamended act is this: initial section 2(4) is only for the purpose of agricultural purposes, land used for like agricultural purposes, and non-agriculture land, though it is falling in the village, is out of the purview of this APRO Act 1971. But by virtue of this amendment, any land falling in the village, whether used for agriculture purpose or non-agriculture purpose, and a gramakantam land, that means small pieces of house sites also may fall within the category of section 2(4). So now this is the initial step where the legislature has brought all lands into the village, all lands falling in a village into the purview of the APRO Act 1971. We will go to the next section 4. What section 4 says is acquisition of rights to be intimated. That means, as per the section 4, if any person becomes the owner of a particular piece of land, a property, has to intimate the authority concerned, that is the Tahsildar, within 60 days from the date of acquisition. If I purchase a land or I succeed a land from my father by way of succession, in either the mode, when I acquire title over a particular land, what I need to do is I need to intimate to the authority stating that, sir, I got the title over a particular property. This is my sale deed, or this is my acquisition deed, or this is my will deed, which my father gave to me. By virtue of this, I became the owner of the property. I need to intimate to the recording authority, that is the Tahsildar, for the purpose of recording my name and deletion of the name of the earlier owner. This is the purport of the APRO Act. The entire crux of APRO Act revolves under section 4, more particularly 4.1 of the Act 1971. That means whoever becomes the owner has to go and approach the revenue officials, Tahsildar, and place before the Tahsildar by way of Form 6A is one of the online application now available. We need to upload this Form 6A through Me Seva Center. We need to enclose all our title documents and need to request the authorities concerned to please record my name. Then procedure, everything was there as per the rules. I don't want to touch all the rules. I don't want to say anything, but rule says the Tahsildar or the authority concerned has to issue notices to the persons who are interested in the land. The rules are framed. There is a format of issuing the notices. In that format, notices has to be sent to all the persons. All the persons in the sense, the first and foremost person to whom the notice has to be given is the earlier owner, because some X is the owner till yesterday. He sold the land to me by way of registered sale deed, but his name is appearing in the revenue records because he already got his name mutated in the revenue records. So I am going and presenting a sale deed stating that, sir, that X has sold the land to me, so please record my name as Y and delete the name of X. So who notice has to be given to the X person whose name is already there. When naturally that X has sold the property by way of registered sale deed, he will come and say, yes, sir, I executed the sale deed, no problem, you issue. There, X may also say, no, sir, I never executed the sale deed. The sale deed is a forged document, and he may claim that he is not the owner of the property. If X person consents, give consent for the purpose of mutation of the name of the Y, basing on the sale deed presented by Y, there is no problem at all. The job of recording authority is very easy. But when there was a dispute with regard to the title or claim made by any applicant before the revenue officials, then the actual problem starts. Then what to be done? Then there is another section 5 deals with the situation. Section 5, there is an amendment again for section 5 from 1/1/2022, Act number 15 of 2022. There was an amendment with effect from 1/1/2022. Prior to this amendment, I will explain what is the situation prior to this amendment. Prior to this amendment, on receipt of an application about the acquisition of title by the Tahsildar concerned, I am explaining the situation prior to amendment. The Tahsildar is the primary authority to decide on the genuineness or decide on the claim or application made by the applicant, and he has to issue notices in forms prescribed under the rules to all the persons concerned, and he has to conduct an inquiry if there is any rival claim or something, and he has to pass orders. Against the orders passed by the Tahsildar, I am saying about the unamended section 5. Against the orders passed by the Tahsildar, appeal was provided to the revenue division officer under section 5.5 of unamended, I am saying. Thereafter, the revenue divisional officer will again take up the appeal. He issue notices and pass orders. Against that appeal, revision lies to the joint collector and section 9. This is the scheme of the act prior to amendment with effect from 1/1/2022. But now, what was a small modification was done. With effect from 1/1/2022, the power of Tahsildar to conduct inquiry and to pass the original order was been removed. And now, with effect from 1/1/2022, the revenue divisional officer, the appellate authority in the old act, was given the power of the original authority, and the revenue divisional officer becomes the original authority, and the revenue divisional officer will call for a report from the Tahsildar. Basing on the report submitted by the Tahsildar, the original authority becomes the revenue divisional officer. He passes the orders about the genuineness or anything about the claim or application made by the applicant, and he passes an order either to accept the claim made by the applicant stating that he was the owner of the property, the sale deed is correct or not, and he will record, or he may also refuse. Then section 5.5, earlier the appellate authority was revenue divisional officer, but now by virtue of this amendment, now the appellate authority becomes the district revenue officer under 5.4. Now the appeal was provided under section 5.4 to the district revenue officer. So this is the major difference in between the amended act with effect from 1/1/2022 and unamended act. Without noticing this, recently in our High Court also, I have came across certain orders where the Tahsildars are passing as if they are the original authorities after 1/1/2022 also, and the revenue divisional officers are also passing orders and entertaining appeals after this date of 1/1/2022. So this is the one of the area where we need to place our objections before the Tahsildar or RDO, stating that, sir, act got amended from 1/1/2022. The original recording authority power was conferred only to RDO, not to the MRO. Similarly, we also has to say that the appellate jurisdiction was conferred to DRO, not to the RDO. So this is one of the difference. Otherwise, only the authorities' powers were changed. But the purport of the act is that the recording of rights has to be done by the revenue officials only. Tahsildar became now the authority who will forward the material to the recording authority, that is to the RDO now, and basing on the material and comments and the records sent by the Tahsildar, the RDO will pass orders either mutating or not mutating. So that is the scheme of the act. Now comes to section 9. Section 9, before section 9, I will finish section 9, then come to 5A later, because this is continuity. Section 9 deals with the revision. Revision is again conferred to the collector, and there are delegation of powers given by the collector to the joint collector. By virtue of that delegation of powers, GO is there and circulars are there. The joint collectors are exercising the revisional jurisdiction. Here there is one peculiar power given to this revisional authority. The revisional authority can entertain a revision on an application made to him, that means a revision filed by any aggrieved party, or suo motu also. So the revisional authority was conferred with the suo motu powers to entertain revision. This suo motu powers is one of the peculiar feature of the revisional authority. First thing. Second thing, against the revisional authority order act, what we will do is we will file writ petition under Article 226, challenging the orders passed by the revisional authority. So this is the channel of hierarchy of the revenue hierarchy for the purpose of making claims or for the purpose of getting the record of rights updated. When once let now the next situation is like this. Let us go to 6A and 6B. 6A and 6B, CD is also there. We are concerned with A and B. There are two steps. One is mutation, another is issuance of Pattadar passbook and title deed. There was a judgment of, I will come to the judgment. First, I will explain. First thing, either the unamended act or the amended act. The recording authority, what they will do is, they will take your application, issue notice, and pass an order. It's a quasi judicial order stating that yes, this applicant is the genuine owner. He got title over the property by way of sale deed, so I am recording his name. This is the mutation order. When once this mutation order became final, other party also not challenged it. It has attained finality. Then the next consequential step is issuance of Pattadar passbooks and title deeds. Now the question is, there are two steps. One is mutation order and another is issuance of actual Pattadar passbook and title deed. Previously, there used to have some confusion. Appeal was provided only against the orders passed by the original authority in passing mutation or refusing to pass mutation. No appeal was provided under the act for the purpose of issuance of Pattadar passbooks and title deeds. So then, a learned single judge of our High Court, Composite High Court, was pleased to consider the material and pass orders. It was reported in the case of N. Balreddy versus RDO Varangal. In this case, what happened is, learned single judge said that when appeal is provided to RDO against original mutation, when no appeal is provided under the issuance of Pattadar passbooks and title deeds, the appellate authority is not powerless. He can exercise the same powers conferred on him, and hence appeal is also maintainable against the orders passed by the authority for issuance of Pattadar passbooks and title deeds. This judgment was doubted and it was referred to N. Balreddy judgment 2004 2 ALT 457. This was thereafter referred to a divisional bench comprising of Justice Dilip Bhosle and Justice S.V. Bhatt. This was in the case of Ratnama versus Revenue Divisional Officer Anantapur, 2015, Volume 5, ALT Andhra Law Times, page number 228, division bench. I once again say this, 2015, 5 ALT, 228, division bench. In this case, the division bench has opined that 6A and 6B, the issuance of Pattadar passbooks and title deeds is only a clerical job or a consequential action of initial mutation. A person who has not challenged the mutation orders is stopped, or he can't challenge the issuance of Pattadar passbooks and title deeds, because according to the learned division bench, what division bench said is, legislature has not provided for any appeal to the appellate authority against the issuance of Pattadar passbooks and title deeds. So what it amounts to means, legislature is conscious of the fact that no appeal is maintainable against the issuance of Pattadar passbooks and title deeds. And if a person wants to challenge, he has to challenge only the mutation orders. And this judgment of N. Balreddy case was set aside, overruled by the division bench. And now this Ratnama judgment is holding the field. This is the division bench judgment. So by virtue of this Ratnama judgment, if at all we want to challenge, appeal has to be only against the mutation orders. But there again we got some problem. What happens is, there will be no mutation orders. Suddenly some ex-person will be given with Pattadar passbooks and title deeds, ignoring the original owner. Then what shall be done? can we file appeal? Then the situation is like this: we need to make an application for rectification of errors, clerical errors, or rectification of records. The issuance of passbook or making webland online entries in favor of a stranger, ignoring or removing or deleting the name of the original owner. Then we have to start from the bottom, stating that make an application under Form 6A, ask for rectification of the wrong entries. It is wrong entry. What is the right entry? If a person makes an application and the authority concerned makes an inquiry by following the procedure, issues notice to the other party, and pass an order, then in ordinary circumstances, appeal will lie. But suddenly, some ex-person's name got reflected in the revenue records online, me bhumi, like that. We need to bring to the notice of the original authority by stating that, sir, this is a wrong entry, this is a mistaken entry, please rectify it. Again, application has to be made under 5, read with Form 6A. Then, if any order is passed, then against that order appeal lies. That is one type. Another type of challenge is we can question the action of the revenue authorities in unilaterally. This is a unilateral changing of entries in the revenue records without following the procedure. We can also question that unilateral decision of the revenue authorities deleting the name of X person without any application or without passing any orders directly in a writ petition under Article 226. But by virtue of Ratnama judgment, we can't file an appeal because there is nothing to be decided in appeal, and only thing is the mutation orders are not there. Only Pattadar passbooks and title deeds were issued. So this is one of the area which we need to take into consideration. So next thing is section 8 is important. Section 8 is important for us. What section 8 says is bar of jurisdiction of civil courts. That says section 8 subsection 1. Section 8.2 is important for us. We need to understand section 8.1 and 8.2 separately. What is the jurisdiction of civil court barred under 8.1 is no suit shall lie against the government or any officer of government in respect of a claim to have an entry made or in relation to any entry made in any record of rights or to have such entry omitted or amended. But 8.2 says if any person is aggrieved as to any rights of which he is in possession by an entry made in any record of rights, he may institute a suit against any person denying or interested to deny his right to such right for declaration of his right under chapter 6 of the Specific Relief Act 1963, and the entry in the record of rights shall be amended in accordance with any such declaration. So if we read the entire scheme of the act, right from 3, 4, 5, 6A, 6B, and 9, and put together with section 8, and also there are various case laws on this right from 1985 or 90s till date 2023. Various case laws are there anonymously or in the same lines what our high court, including the division bench, said is that the entries in revenue records will not confer any title. They are only an entries in the revenue records. At the most, they can be used to show your possession over the subject property. First thing, this is the first principle. I don't want to give all the citations. I don't want to say all citations also. There are many citations. This is the principle settled by our High Court, stating that the entries in revenue records will not confer any title. First principle. Second principle is the entries in revenue records are only useful for the purpose of proving your possession over the subject piece of land. Third thing, the revenue officials have no power to decide the title dispute. The same example, X comes and places a sale deed stating that, sir, Y has sold the property to me you please mutate my name, you please record my name in the place of X, delete the name of X, mutate my name, record my name. Then notice has to be given to that Y. Y comes and says, oh no sir, this is not a sale deed executed by me, this is a forged document, I am objecting for this. Then what the revenue authorities have to do? As per the scheme of section 1971 Act, as per the scheme of section 8(2) of the 1971 Act, revenue department, revenue officials, either the original authority or appellate authority or revisional authority, has to say that there is a rival claim, there are disputed questions of facts, you both go to civil court and get your rights declared from the competent civil court. Whoever got a judgment, I will record that. That is the purport of section 8 subsection 2 of the APRO Act 1971. Because of this reason, what is the power given to the revenue officers, either the original authority or appellate authority or revisional authority, is only to record the names of the persons who got title. They were not given the, and what the inquiry, what they can conduct is a summary inquiry, not touching the title dispute or rival claims. It is only summary inquiry basing on the documents. If suddenly some third party name got entered, ignoring the original owner, then notice will be given. On an application made by the original owner, notice will be given. If this party is showing that, sir, my name is already there till yesterday, this is my sale deed, already 10 years back my name was mutated, this gentleman's name got recorded without any application or mistakenly or something, then in a summary, it's a summary inquiry. One person is already having name, his name was wrongly deleted or due to fraud or something. That gentleman whose name got entered has no title at all. He is unable to place any title document. Then the course open to the revenue officers is that entry is a mistaken entry or wrong entry. Then that wrong entry can be deleted and the original Pattadar's name can be re-entered. This is a summary inquiry. But if both parties are claiming title either for the purpose of succession, now this problem also comes in the manner of succession. One person comes and says, sir, X is my father, he died, he gave will deed to me. Another person comes and says, oh, no sir, he is not the original son, I am the original son. And he also places some documents. In those circumstances, revenue people cannot decide whether Y is the owner or Z is the owner, whether he is the actual son, whether he is the actual son. All these things are outside the purview of the inquiry to be conducted by the revenue officers under the Act 1971. That is the reason section 8 subsection 2 says you refer the parties to the civil court if there is any rival claim. And whatever the judgment given by the civil court, it is binding on the revenue authorities. They will record the records, they will update the records basing on the judgment rendered by the competent civil court, the two declaratory suit under chapter 6 of the Specific Relief Act 1963. So this is the purport of the scheme of the 1971 Act. Apart from this, there is one provision, section 5 capital A. Section 5 capital A is one of the additional feature or some powers were conferred on the authorities concerned. Alienation of certain regularization of certain alienations. What section 5A says is regularization of certain alienations or other transfers of lands. If at all any person sold the property and other person purchased the property by way of an unregistered document, then they can go and present that unregistered document before the Tahsildar concerned, and the Tahsildar can take it into consideration and he will collect the stamp duty and the registration charges as applicable under the rules, and he will pass order stating that I am regularizing this unregistered document. This is one of the peculiar power conferred. Here, the language of section 5A is very clear. Notwithstanding anything contained in this act, the Transfer of Property Act 1882, the Registration Act 1908, or any law, any other law for the time being in force, where a person is an occupant by virtue of an alienation and or transfer made or affected otherwise than by registered document, the alienee or the transferee may, within such period as may be prescribed, apply to the Mandal Revenue Officer for a certificate declaring that such alienation or transfer is valid. That means the condition precedent under section 5 capital A is that he shall be in occupation otherwise than a registered document. That means due to ignorance or due to illiteracy or not knowing or for some reason or other reason, he purchased the property and he is in occupation of the property by way of unregistered document. Then if he approaches the Mandal Revenue Officer, irrespective of the fact that that property was unregistered, this Mandal Revenue Officer got power to issue a certificate and regularize such unregistered document, and he can issue certificate. But for that purpose, he will collect the stamp duty and charges whatever applicable, because there cannot be any loss to the revenue department. He will take all precautions. For this, rules are also there, and subsection 2 is also there. Subsection 2 says, on receipt of such application, the Mandal Revenue Officer shall, after making such an inquiry as may be prescribed, require the alienee or the transferee to deposit into the office of the Mandal Revenue Officer an amount equivalent to the registration fees and the stamp duty that would have been payable had the alienation or transfer been effected by a registered document in accordance with the provisions of the Registration Act 1908. That means there was some mistake or error or ignorance about the registration of the document. Both parties have not registered the document and they are continuing with unregistered document. Today they want to come and get the unregistered document regularized. So this was the power given to the Tahsildar. That too, he will collect the stamp duty or registration charges, whatever it may be. He can pass orders under section 5A. Then against this 5A, again there was an appeal provided under 5B. Appeal is to the revenue division officer within 30 days of the passing of the order passed by the Tahsildar. So these are the important provisions for the purpose of AP RO Act 1971. I will pause here because we will skip schedule to the next Land Titling Act. I will pause here. If anyone wants to have any clarifications, you please ask me, because we are switching over to the next latest topic of 2022 Act.
Now, the audience are allowed to ask your questions, and please unmute yourself and ask that specific question.
Sir, Suresh, sir, I have a question.
Yes, sir, please.
Yes, sir. So, very good morning.
Good.
As per section 4 of the RO Act, the purchaser approaches the revenue authorities, right, to request them to mutate his name, right? Is there any limitation after having purchased the property to approach the revenue authorities? One aspect. The other aspect is the earlier owner, after having received the notice or without receiving the notice, when he has to approach the revenue authorities, is there any specific limitation to that effect?
Yes. 4.1 itself provides for 60 days limitation period.
Okay.
60 days limitation period. But in practically what we are seeing is this limitation period of 60 days is not adhered to, if I can say so. First thing. Yes. Because in a routine process, even we are the purchasers, we can have we can also may go or may not go. But there is one provision I forgot to say.
Yes.
6D. Now there was a recent amendment to the RO Act. Section 6D was incorporated.
Okay, sir.
6D has connection with the 2022 Act.
Okay.
6D, to avoid any fraud, to avoid any wrong persons, executing the sale deeds, because we used to see various litigations. A non-owner comes and he executes the sale deed. Original owner, his name is there, he will be in the land, he will be having his own rights with RO Act. So that is the reason 6D was incorporated. What 6D says is, The registering authority appointed under the Registration Act 1908 shall effect the registrations on the basis of entries in the revenue records, record of rights maintained electronically, and shall not insist on production of title deed cum passbook. There is no there should be no requirement of making an entry of the sale so and so. So section 6D, this was also challenged before the High Court, the constitutional validity. A rider was given to the registration officers stating that if X wants to sell a property and Y wants to purchase,
Correct.
the name of X shall contain in the webland register, online register, to avoid any impersonations,
Correct.
to avoid the future litigations placed before the revenue authorities, either before Tahsildar or revenue division officer. So a person, if they wants to sell the property, first his name shall be there in the revenue records under section 6D. Then he can present a document to the sub-registering officer. This power was given to the sub-registering officer to comply with section 6D. Before this amendment, before section 6D's introduction, we used to have the concept number of judgments, including the judgment of Justice N.V. Ramanujar of the Composite High Court in 2008, 2009, followed by Justice Vilas Afzal number of Justice S.V. But number of single judge judgment. Registering authority has no power to look into the title. This is the settled law previously.
Yes, yes.
But now, by virtue of section 6D, registering authority has to insist for show your entries in the revenue records.
Correct.
Basing on these entries into the revenue records only, registering officer, and this section was challenged. This was upheld by our division bench. Yes, I will give the citation also. K. Anantarao versus State of Andhra Pradesh. K. Anantarao versus State of Andhra Pradesh. 2013, Volume 6, ALT, Volume 6, ALT 708, Division Bench. This is by Justice Kalyan Sen Gupta garu and Justice P.V. Sanjay Kumar garu.
Sir, please repeat again, sir.
K. Anantarao versus State of Andhra Pradesh. 2013, Volume 6, ALT, Volume 6, ALT, Andhra Law Times, page 708. You please, because this writ petition was partly allowed and section 6D was upheld, but some certain observations were also given what to be done and what not. So this is the situation, sir.
Right, sir. Thank you so much.
Thank you. So now we can move on to the hot topic. Initially, I was asked to say only RO Act. Jampan Sridev also asked me and added the present subject of Land Titling Act 2022.
As per the audience request, sir, I got call from different bar associations.
Yes.
So this Galaxy M20.
Okay.
Guy
Now,
he is having some doubts, sir.
One question, sir.
yes.
Regarding section 5A, you have mentioned that we need to get a certificate, and if there is a regularization of certain alienations or other transfers of land. In this particular section 5A, is the certificate sufficient enough for mutation also? Is there no need for, because this particular section does not provide for any mutation. It directly talks about the certificate and the entries in the passbook.
Correct. That's what I'm saying. Your 5A is the unregistered sale deed will be registered, regularized.
Sir.
Your unregistered sale deed will be regularized.
Okay, so there is no need for any separate mutation application also in this particular section.
This will not speak of any mutations. Section 5A 4. ఒకసారి 4 మీ దగ్గర యాక్ట్ ఉన్నట్టుంది చూడండి ఒకసారి.
Please, sir.
4. 4 says about section 5A 4 says about procedure to be done. That is order passed. Certificate will be issued.
Yes, sir.
Then 5A 5.
It directly talks about the entries into the passbook.
The recording authority shall on the production of title, production of the certificate issued under subsection 2, make an entry in the passbook.
So it is basically skipping the mutation process itself.
Because
Okay.
already inquiry, they are doing inquiry, every inquiry is done.
Okay.
5A5 is the answer for you.
Yes, sir. Thank you, sir.
Thank you.
Thank you so much, sir.
Thank you, sir.
Have a great day.
Thank you, sir.
Thank you, sir.
Thanks, sir.
I personally thank you very much. I started my career in Supreme Court. I don't have any foundation in trial side. Today, I have benefited more. The way you have enlightened and encapsulated very effectively, efficiently, and very precisely, sir. I have very much thankful to you.
Thank you. Because for us, even in High Court, we will have an access to the client, and also we know what is happening before MRO and RTO.
Yes, sir.
But coming to your Supreme Court, sir, we will send you the paper book. You will be preparing everything on paper book.
Sometimes we can't see the client. Who is
Correct.
the client?
Correct.
You are right, sir. Thank you so much.
Thank you, sir. Thank you very much.
Thank you so much, Suresh garu and Sridevi garu, because you spared a lot of time of 3 hours. I have been followed so many other legal forums. They are giving only 1 hour only. Because of 1 hour, I was unable to express the people all the queries. Because of giving 3 hours time, everyone got the good opportunity to raise all those. Thank you very much.
Very interesting. Suresh sir is highlighted the things very effectively. That's why we patiently sitting and heard it.
Because I wrote the book on APRO Act 1971 recently, and I added this Land Titling Act also, because commentary I have not given. I am waiting for rules and other things. After rules comes, I will give the commentary also. I wrote the book exhaustively APRO Act 1971.
Thank you, Sridevi ma'am.
We have another session.
That's why
This is my new book. ఇది రివర్స్ లో కనపడదు. I doubt it మీకు రివర్స్ లో కనపడచ్చు.
రివర్స్ లో లేదు సార్.
బానే ఉంది, కరెక్ట్ ఉందా? This is దీనికోసం చాలా ఎక్సర్సైజ్ చేశాను నేను.
పబ్లిషర్ ప్లీజ్.
మేడం అది బుక్ అది ఏమన్నా పాసిబిలిటీ ఉంటే వాట్సాప్ గ్రూప్ లో పెట్టండి మేడం.
పంపిస్తాను.
ALT కదా సార్?
I wrote this book.
సార్ అందుకనే సారు రాసిన దానికన్నా చెప్పింది ఇంకా ఎఫెక్టివ్ గా ఉంటుంది అనే ఉద్దేశంతో అడగటం జరిగింది. సారు మన రిక్వెస్ట్ ని కన్సిడర్ చేయటం జరిగింది. Likewise, many of you are expert in different areas. We are requesting you all to extend your help for the upliftment of the advocates. So మీరు తలా ఒక టాపిక్ ప్రిపేర్ అయ్యి నాకు ఒక టెక్స్ట్ మెసేజ్ చేస్తే వీకెండ్ సెక్షన్స్ లో we can have this kind of conversation so that we will improve our knowledge. And with this we conclude today's session. And I really thank you, sir, PSP garu, for giving this wonderful lecture. And the people who have participated also, I would like to thank to them. So with your interest, with your this kind of enthusiasm, we can make many number of sessions, and that will help even to the remote people can access the law through this our webinars. Thank you, one and all.
Thank you so much. Thank you for the.
Thank you.
Thank you.
Thank you, sir. Thank you, madam.
Thank you, sir. Thank you very much.
ఫిజికల్ గా కూడా ఒకసారి సెమినార్ కండక్ట్ చేస్తే బాగుంటుంది.
And this will be uploaded in my Egna Legal YouTube channel for the verification and for the revisit of this class. Thank you, sir.